original straw man trust. Mom was the exchanger, the trustor. Mother applied to the state for the creation of a trust. She chose the date of birth for it. She chose its name. She requested evidence that it had been created, i.e. a birth certificate, which is evidence of a trust. She was the informant. She delivered the paper description of the original property to the trust creator. It was a description of the real substance. The paper description was the original trust corpus. More trust property would be added later, like the money. It's all just ticks in a book, but the many millions in there, you can't get to it, but they can. So let them. The state was the creator of the original trust. The state complied with Mom's request and created a straw man with the name and date of birth your mother requested. She applied for a social security number for it. She put it into commerce by getting it medical numbers, etc., etc. Little league numbers. Who is the beneficiary of the original trust, by the way? The beneficiary changes each time a new trust is created. You're the original beneficiary, though. You're the executor and the beneficiary. Never be the trustee. If you choose to use your beneficial interest, that is. If you choose not to use it, the citizens of the state that created it are the beneficiaries. This is part of the highest and best use principle. If the property is not being put to its highest and best use, then it can be borrowed for a time and put to better use. You have not been using it. You have not filed any claims against it, so why should it just sit there, not being used? This first trust was created for your benefit if you choose to use it. And this is the perfect example of a time to use it, by the way, when you're in court. The judges have access to the trusts, so authorize them to act as your trustee and settle the matter. They know what to do. So if you choose to use it, now remember the reason that the first party, the creator, creates a trust is for the second party, the trustee, to manage the trust corpus for the benefit of a third party, the beneficiary. What is the trust corpus? The state complied with Mom's request and created a straw man with the name and the date of birth she requested. Mom is the one who put your physical description on the application for the certificate, which is evidence of a trust. She delivered the description, 7 pounds 11 ounces, 19.5 inches long and a footprint. All of this was on paper. The paper is the trust corpus, the res. That was the consideration that was exchanged into the original trust. Exchanged for what? Exchanged for the ability to gain possession, not title, of houses, cars, shoes, books, etc. without paying for them. Guess what, guys? Everything in this life is prepaid. She applied for a social security number for it. She put it into commerce by getting it medical records, Little League ID number, library card. They are all part of the trust property. As evidence to contractual obligations the trust has, or as collateral for debts the trust owns. It appears the trust is using your description and your credit to gain assets. It has an obligation to you. Because of that, maybe these assets can be considered benefits for you, which you owe an obligation because of your close relationship with the trust. Or these assets can be considered collateral for the debt the trust owes to you. Who is the trustee? On the private side, if you're an appointed trustee, or if an appointed trustee resigns or dies, the trust corpus reverts to the beneficiaries or back to the trustor. It is useless to create a trust without appointing a trustee. It's like a game of hot potato in the courtroom. Who's going to be the trustee? The trustee created by the state, upon mom's request, must also have a trustee. Oh, the trust that they created must have a trustee. Of course, the problem is, depending on how it's going to be used, the creation of the trust is a matter of construction and operation of law. This is a constructive trust. That means that you could probably construe it in many different ways. A constructive trust is one that is created by operation of law against one who by actual or constructive fraud, by duress or by abuse or confidence, or by commission of wrong, or by any form of unconscionable conduct, or other questionable means, has obtained or holds legal right to property which he should not, in equity and good conscience, hold and enjoy. Construction, drawing conclusions respecting subjects beyond the direct expression of the terms. Operation of law. This term expresses the manner in which rights and sometimes liabilities devolve upon a person by the mere application to the particular transaction of the established rules of law, without the act or cooperation of the party himself. Oh, that doesn't sound good. Default, an omission of that which ought to be done. That's a default. Specifically, the omission or failure to perform a legal or contractual duty. There can be more than one trustee for a trust. You can be co-trustee. One trustee may have the duty of performing certain actions of the trust. Another trustee may perform different functions. The identity of the trustee or trustees of these individual trusts is often not expressed. That's right, it's a guessing game. And there is no requirement for there to even be a written trust indenture. Did you hear that? On the public side, there must always be a default trustee. Ooh. Understand that. Don't get put in that position. Only the trustee can go to jail. Only the all caps can go to jail. Now, if either that's how you spell your name or it isn't, you need to understand for yourself and stand on your square. Hey man, that's not the way I spell it. They went to school. They understand. Stand on your square. Don't allow them to spell it that way. It's ridiculous. These are the rules of grammar that we all have to agree on. Are we back in 4th grade? Give me a break. Okay, in some states, the SOS would be the logical default trustee, Secretary of State. Right. It goes back to Secretary of State. When there is any question at all, they will take it. They will take the position of trustee. In other cases, the lack of a trustee may result in a presumption that you're the trustee. Trustees have a fiduciary duty to manage the trust honorably and for the benefit of the beneficiary, which that's you. You're the executor and the beneficiary. A trustee may not use the trust for personal gain. You hear that? A trustee that is acting outside his duty is not performing at all in breach of his fiduciary duty. That is not tolerated on the private side or the public side. Trust law is God's law. No one breaks it. They don't let anyone break it. Trustees in breach of fiduciary duty are held personally responsible for the breach, and they take on the financial penalties for their actions, malfeasance, or lack of action, nonfeasance. So, they are always on the hot seat. Always. Here's an example of a typical court scenario when a man participates, investigator from ABC agency, or a municipal corporation has filed an information with a prosecuting attorney. On the public side, affidavits are not required. The informant is not required to sign an affidavit. Wow. and submit it to the attorney to commence a public action against the individual being investigated. That's a big drag. Affidavits were required in equity when someone wanted to file a claim in court. If you're coming after me, you better have an affidavit. Someone better have put their name on the line to say they swear that all the information is true and complete and accurate. Otherwise, get the fuck on. It has nothing to back it up. It needs to be a verified complaint. It's the signed affidavit if you're coming after me. I'm just letting you know that. Now, affidavits were required when someone wanted to file a claim in court. In admiralty, in the public, affidavits are no longer required. They have been replaced with what is called an information. This is a total drag. An affidavit is signed under oath. The statements made in an affidavit are the signer's bond. His word is his bond. It damn well better be. You know, don't be bringing frivolous lawsuits up in here. No, nobody has time for that shit. The affidavit formally bonded the case. Now that there are no affidavits, there are no bonds to bond the case because nobody wants to put their name on the dotted line and swear that it's accurate under penalty of perjury in the state where they live. That's a big weakness that they have. Did you hear what I said? You have to use whatever few weaknesses they have against them. None of them want to put their name on the line. That's a huge weakness on their part, so you got to use that against them. Just put your affidavit forward. If they don't rebut it, then your affidavit becomes the judgment. Simple. In this case, we are dealing with an information. Okay, so the prosecuting attorney has to decide whether or not to commence an action. I mean, it's a simple matter as far as is it going to be worth it for him? You know? Is it a worthwhile endeavor? So the informant may have completed an administrative process. He should have already completed an administrative process by sending letters himself personally to the guy first. IRS, a 90-day letter, 30-day letter, 10-day letter. That's how they do it to you. That's how you need to do it to them. Just write them letters. That's it. It's not difficult. For the attorney as the basis for bringing the action. Yes, you shouldn't bring an action unless you already wrote to them about it and tried to settle it yourself and you have proof of that. And if they didn't respond, boom, you got them. Okay? So send your letters to people because they usually don't respond. And if you can prove they didn't respond, you got them. They had their chance. It may not have started an administrative process. 9 times out of 10, the administrative process is not needed because they are almost sure you will agree, without knowing it, to represent the accused individual, the trust, the strawman, by volunteering to act as his trustee. The attorney is going to create a new trust to be the accused on the complaint or indictment. If you go into contempt for defending and not taking responsibility for the new trust, you will either pay with the trust corpus or you will go to jail. And your credit, your exemption, will be tapped during the time they're housing you and feeding you and giving you medical treatments. They get $10,000 per day, per inmate, with the bonds that are backing each inmate. And every single one of them agreed to be the trustee. So if I were you, I would make it real clear to some people that, hey, I don't agree to be the trustee. I don't agree to be the surety. In any case, you better make sure that they got that clear. Because only the trustee can go to jail. Only the all caps can go to jail. So make sure that they don't think that's you. Even if they had your name on a piece of paper spelled correctly, that's still not you. You're the living man or woman. You're not a piece of paper with some writing on it. Okay? So, the attorney is going to create a new trust to be the accused. If you go into contempt for defending it, You will either pay with the trust corpus or you will go to jail. And your credit, your exemption will be tapped during the time that they're housing you, giving you medical treatments. The trust corpus might include the balance in a bank account, a title to real property or a car or any other public asset. Creator. The attorney is the creator of the accused trust. So he better put his money where his mouth is. They never do. Bam, use that against them. It might be John Henry Doe, the all caps. It will be the all caps. Notice that they never put your name as a proper noun on the complaint, indictment, or traffic ticket. Even if it is written in uppercase and lowercase letters, it is still a fiction and a trust, even if they did spell it right. It's true, right? But we cannot mix public and private. So this is a problem with their paperwork, and you need to call them on their problems with their paperwork and let them know, hey, I'm more than happy to move forward and accept this paperwork and settle the matter once you correct the errors in the paperwork. You're not arguing, you're just asking them to correct the errors, and then you'll deal with it. Okay? Because they're not going to want to fix their errors. So, but you have every right to make them. You have every right to mandate that they should correct their errors. Or you're not going to deal with it because you don't have to. If they don't spell your name right on legal paperwork, then it's over, bro. It's a wrap. It needs to be spelled exactly correctly, bro. And doesn't everybody know that? Or it's not you, period. So, the trustor, the attorney, is also the trustor. Yes, he's created this trust that he's coming after you with. He is putting the trust corpus into the trust. That is the charge. It is a debt, a liability on the public side, and a credit, an asset on the private side. We have always presumed a charge is a bad thing, but it's only bad if the man is found in contempt of the process, or in contempt of the attorney, or of the judge, or of a number of other possibilities. It is very easy to go into contempt. If you don't agree to take responsibility, you will be in contempt of our presumed fiduciary duty. Creditors do not go into contempt. Do not argue any of the facts of the case. The facts are on the moon. They don't matter. Creditor always wins. Debtor always loses. That's it. It's just about the money. That's all. Simple. It's just business. It's not personal. Beneficiary. The beneficiary is the state of California, which is also the plaintiff in this case. It is the person that stands to gain from the charges, the trust corpus. But it only has the equitable interest in the trust corpus. That way, the beneficiary is not held responsible for bringing a claim without a bond, evidence of a debt. The attorney does it instead. And it better be in there. Or you're all good. If it's not in there, you're all good. Go ahead and post your own bond. As well you should. Post a bond to any court case that you have. And it's the only responsible thing to do. If you want to settle it and get it handled and go on and move about your business to something more interesting that we could all be doing, okay then. Let's settle it. All right. So the plaintiff seldom signs the complaint. That's a problem. The attorney's signature is usually the only one on it. That's true, and that's not good enough. Not for me, it's not. An unverified complaint? Get the fuck on. I don't have time for that shit. So the beneficiary has to hold on to its creditor position. And it can't do that if it brings unfounded claims. The trustee, this is the trust position that carries all the liability. The trustee has a fiduciary duty to manage this trust property for the benefit of the state of California. Oh, they put themselves as the beneficiary now. If it does not, the trustee accepts the responsibility for the losses suffered by the beneficiary. The state? There is no appointed trustee. There is a presumption that there will be a trustee when it is needed. They're going to get you in at the last minute. Okay? The attorney has the complaint served on the original trust with a name like the accused individual, the defendant trust. Someone has to represent the defendant. At this point, the only representative for the trust is its creator, the prosecuting attorney, which has made a commitment to the beneficiary, the state, that they're going to make some money, and they're counting on this. Okay? Don't waste their time. That's not cool. Once the charge is signed by the attorney and delivered to someone who might volunteer to be the trustee, the attorney does not even have the option of withdrawing the charge without the defendant's agreement. That's a rule of court, since the complaint was delivered into your hands as the presumed trustee and surety. Now you have agreed to the withdrawal of the charges before they can be withdrawn. As soon as you hire a good attorney or decide to defend the trust yourself, the liability has moved from the prosecuting attorney to you because you accepted it. And that's what he's banking on. If you don't, he's in trouble. He's on the hook. But you usually do. The fact that you are defending all by itself is a dishonor. If you don't defend anything, you're not defending, you're not arguing. You're just accepting it. So, don't allow anyone to call you the defendant. You're not you're not defending anything. Make that clear. Anything other than an all-out acceptance is a dishonor. So don't argue about even the littlest thing. Don't worry about it. The facts are on the moon. Nobody cares about the facts of the case. Please. Nobody cares about the facts of the case. Please stop talking about the facts of the case in the courtroom. It's just irrelevant. Your dishonor is what gives the prosecuting attorney the energy to bond the case. So they just had the system set up for you to always be in dishonor because they don't want to come out and ask you for your authority and approval to tap your trust. They don't want to lower themselves to asking you properly. So they just set up the system to do it in a dishonest manner. It's just more efficient. Whoever is in dishonor is the debtor. Are you getting that? Whoever bonds the case is the creditor. And yes, all cases have to be bonded. Put your money where your mouth is, dude, or get the fuck on. I don't have time for that shit. You can plead not guilty. You can testify, defend, call witnesses, question witnesses, file motions, file a countersuit, answer questions, or not respond at all. Just to name a few ways to volunteer to be the trustee. And to be that's not to be an honor. Your voluntary dishonor will authorize the use of your credit to bond the case. So they're going to get it either way. No big deal. It's nice to finally. I'm glad we're finding this out, so we can actually handle our business in a sensible manner. I'm tired of the shenanigans and the tomfoolery in the courtroom. Condescending attitudes. Being treated like a child. It's ridiculous. People just want to handle their business and go on, do something more fun with their time. Give me a break. Since you did not voluntarily bond the case, you are in dishonor. Period. So nobody can get mad at you for posting a bond to your court case, as well you should. No one can get mad at you for it. Since the standard script will be used for the court event, it is likely the man who has volunteered to be the trustee for the accused trust. He's the surety. He will defend the trust. That will guarantee the standard outcome. The defendant will be found guilty and the trust corpus will be liquidated enough to pay the judgment debtor or the judgment debt. If the event involves criminal charges, the man's body will be jailed so the state can revenue the man's credit from private into the public state. Okay? This is what keeps the public machine running. Revenue. The man will be the surety for the judgment debtor once the trust is found guilty. Who is the defendant? Is it you? I don't think so. For research purposes only. Plaintiff, the state, the beneficiary is the plaintiff and presumed creditor as long as the man plays by the standard script. Defendant, the prosecuting attorney needs to have a volunteer to defend the trust or he will be stuck representing the accused trust himself. He is the defendant actually, but he does not plan on holding the position very long. I told you it's a game of hot potato in the courtroom. With the help of the judge and the defense attorney, they're all in it together. The prosecuting attorney will be able to pass the liability on to the trust and its representative and surety, which is you. But you have to go into dishonor for this to happen, which is very easy for them to put you into dishonor. Like we said, this is how the system is set up, unless you're different. Maybe you don't automatically bow down to their jurisdiction. Good for you. As well, you shouldn't have to. It should just be a simple matter. All charges, arguments, and testimony are dangerous in public court. Don't engage in those activities. Remember, it is not your court. They can only see fictions. So if you are testifying, then you are recognized only as a fiction, as you are a piece of paper at it. But if you are talking to him, he presumes you are the trustee for the trust, period. In that capacity, he can talk to you. He is expecting you to breach your fiduciary duties by going into dishonor. Then they win and you lose. You want a win-win situation, which can be achieved. Now that's good business. Be careful, even with the copyright. If you can bring the copyright into the case without testifying, through third-party witnesses, you may be able to stave off a demand for trust property. If you have already given the right to use the now copyrighted name to a corporation, you cannot revoke it, that authorization after the fact. You may have done that by applying for a loan. You gave them the use of the name on the application. You can give the use of the name on a driver's license application. You are the one who tells what name to put on the license. You can't come back later and charge them for using the name you previously gave them. If there is no driver's license application, you may be able to give notice of the copyright to the officer and then enforce the copyright violation because he had notice of your restrictions to use the name. Even if the car is registered with the state, you may be able to use the copyright in this action if you know how, and do not dishonor your own claim to being the private owner of the name. Here's a different scenario when the man does not participate. An investigator from ABC agency of a municipal corporation has filed an information with a prosecuting attorney. Before things get this far, you should have completed your administrative procedure on the activity that is the subject matter of the court case. The prosecuting attorney has decided to commence an action. The attorney creates a new trust to be the accused on the complaint or indictment, which is delivered into your hands. This time you accept the presentment for value, return it, and authorize the use of your credit, and bond the case. Boom. You give notice to the public of these private actions you have taken. You use third parties to testify to the agreement of the parties. When you accept it and return it to them, and they stay silent, they accepted it. That's an agreement of the parties. Now you can bond the case. You have an agreement of the parties. Do you understand how you get that agreement? By accepting and returning. having an agreement of the parties is a wonderful thing, I'm telling you right now. You can now bond the case. You do not have to be the trustee and represent the accused trust to take responsibility for the presumed violations of the state statutes. You are one of the people. You are a creditor with priority over fictions. You are the one who has the power to create a win-win situation for all parties. Creator. The prosecuting attorney is still the creator. Trust name. The name of the trust is still John Henry Doe, all caps. Trustor. The prosecuting attorney is still putting the charge into the trust as a corpus. Beneficiary. The beneficiary is still the state of California. Trustee. Since you have not volunteered to be the trustee, the prosecuting attorney is still the responsible party. I told you, it's a game of hot potato in the courtroom. You are the one who accepted delivery of the complaint that was sent to the trust over which you are presumed to be the trustee. Now, if you can stay in honor while you take on the obligations of the trust by using your exemption, utilizing your exemption, which is that's your asset, is your exemption. Get that through your head. That's the only asset you have, but it's a good one, and they all want it. So, let them have it. Understand that that's the asset you have. It's your signature. And your exemption, your private exemption. So, discharge the obligation through your private exemption. Boom. Now, by using your private exemption and your credit as surety for the trust, you will be fine. You can argue with the attorneys and the judge and the witnesses and the clerk showing how bad a trustee you are, or you can accept the state's request for revenue and authorize the use of your exemption, your credit. It's your choice. You can't use the credit. You can't use the credits that were in there, okay? But they can. So let them. Surety. The suretyship on this case can be shared. Suretyship is a voluntary act. Be careful. You can volunteer to be the surety using your exemption credit. Someone else can volunteer to dishonor someone or to dishonor the process, thereby becoming the surety. Free will is always a factor here. The big question is, who will be the surety? Since there seldom is a bond in the case until after the trial is over, then you can present your bond to bond the case. Bam. It's simple. Plaintiff. Whoever bonds the case becomes the plaintiff. Whoever bonds the case is the creditor, and creditors always win. Charges cannot be brought unless there is a bond. And if you're trying to bring a complaint to me, it better be there, or don't even think about it. If the man supplies the bond, the man is the creditor, period. The tables can turn, and that's the beauty of it. It's simple. Once you know the rules, you can use them to your advantage. It's nice to know the rules. We have to admit to ourselves that we didn't know the real rules before, but now and then we can learn them. Okay, if that's something that people are interested in for research purposes only. I don't give legal advice to anybody. Please be advised. Whoever bonds the case is the plaintiff. Charges cannot be brought unless there is a bond. If the man supplies the bond, the man is the creditor. The tables can turn. You can do a counterclaim by removing the case into another court for judicial review of your administrative process and get an estoppel on their case. Defendant. The prosecuting attorney is the defendant, unless there is a defense attorney who has put a notice of appearance into the case. Let's go check the record. Is one in there? Okay. If so, then the defense attorney is the defendant. As the creditor, you can authorize the prosecuting attorney or defense attorney, if he has filed his notice of appearance, to write the check to settle the account. The check is backed by your bond. Bam! That's how you settle it. It's all ticks in a book. That's what that money is in there for. It's just ticks in a book. That's what it's there for situations like this. Hypothetical situation. A few months ago, ABC agencies sent the John H. Doe Trust an administrative presentment with a charge energy of $5,000. It wants or needs $5,000. You are the source, you're the banker. If you don't give it to them, they will use your dishonor to support a claim to $5,000 worth of trust property. You accepted it for access value, $5,000, returned it, gave them an authorization to use your credit, exchanged your exemption for the discharge of the charge. Your acceptance is the return of the energy. They received your authorization, which may have been a bill of exchange, a bond for discharge, or other credit instrument you chose to use. I'm talking about a one piece of paper document, okay? A one-page document. For example, they received your authorization. Now ABC agency has hired an attorney to bring charges in the public court against John H. Doe. All caps. A summons and complaint were delivered into your hands today. What do? 1. Realize this first. You are in the courtroom on your case. John H. Doe may have removed ABC's case to a different court by filing an amended complaint, requesting judicial review of your administrative process. The purpose of this case is to get a public order that will overcome the claims being made in ABC agency against John H. Doe, all caps. You have to introduce evidence into the judge's file to give him facts upon which he can base his decision. If you are asking for findings to facts, he must have some facts in the evidence file. You don't want the respondent to enter evidence and have his be the only evidence upon which the judge will base his decision. If you want conclusions of law, he must have some law in front of him in the evidence file on your side. The only way facts and law get into the evidence file, the one the judge keeps in his possession, the clerk's file, to the bailiff or the judge's clerk, who will then hand it to the judge. That's how you get something into the record. You do it in open court, you hand it to the bailiff to give the judge. That's the way to do it. Have a copy for the attorney too. Have copies for everybody. A copy for the clerk, copies for everybody. Hand it to the bailiff. Boom, he's going to hand it to the judge. It's beautiful. It's perfect. Don't try to hand it to the judge yourself. You do not need to do this if there is a public defender. You have to introduce some law that supports your request into the record to give him something from which to make conclusions of law. Putting this into the complaint as an exhibit and filing it with the clerk and giving notice of it to the respondent does not get into the judge's file. You need evidence and facts and law. What do you want the judge to do? You have to make the order too. You have to also make the order yourself of what it is you want done. And make it simple so all the judge has to do is sign it. Boom, that's it. Do all the work for them. That's what you have to do. It's your case. Put your judgment forward for him to just sign off on. Just look for an example of that type of document on Scribd or what have you. This is the time, before you even do your administrative process, to decide what you want and what evidence you will need to support what you want. What you want the judge in this case to do. Even if you do not quote the statutes, the notary's certificate is recognized as prima facie evidence of fact contained therein. The certificate of dishonor or certificate of breach. Certificate of non-response is really important. You write them a letter, they don't respond, get the certificate of non-response. Boom, it's super powerful. It's everything. simple thing to do. The administrative process is very, very powerful, very, very important. And it's just writing some letters, okay? Send them certified mail. Since your administrative process will result in a certificate, boom, give me the judgment, okay? And they will. This is the time for you to decide what you want from the one that sent the presentment to the straw man. Put the horse in front of the cart, or you may find that your certificate did not contain the exact wording you want to use in the certificate. It cannot be changed after the fact because the notary would be accused of making legal determination or practicing law. Prepare the certificate of non-response. It is important. It's everything. This is the notary's certificate. It is not yours. The notary will issue it to you. You will then be the holder of the certificate. It is like a bond in that it is evidence of the debt owed to you by the respondent who dishonored you by not responding or not complying with a duty. If the prosecutor doesn't do what he's supposed to do, he's in trouble. He's on the hook. Hit him with the certificate of non-response, and he's done. The certificate is 3 because it will be issued after the respondent has had 2 opportunities to honor you by complying with your request or performing a duty that was required of his office. His communication is not a response to your notice of acceptance and request or to a notary's notice of non-response if it addresses some other issue, so don't do that. If his response is an argument or testimony, he is in dishonor. Okay? So it's easy to get him in dishonor this way. He's going into dishonor with the certificate of non-response, period. And he's done. If you used a bill of exchange, name of notary, name of presenter, name of acceptor, description of presentment, name of accused, state commercial statute regarding notary certificate. Certificate statement. Notice that the presentment was accepted and returned with attachments, with a request to the presenter at his company at its address by certified mail with return receipt and certificate of service. Notice of non-response with a second request to the presenter at his company at its address by certified mail with return receipt and certificate of service. Presenter refused requests. Presenter did not send notice of dishonor. The presenter did not cure his dishonor. The presenter agreed, therefore. When he doesn't respond, that means he agrees to all of it, period. He agrees that he dishonored the acceptor accepted the presentment, the acceptor returned the presentment, the acceptor exchanged his exemption for discharge, the acceptor presented authorization to use his exemption for court charges, the acceptor sent processing instructions with the authorization, the acceptor sent a statement of account showing a 0 balance. His refusal to send the confirmation or notice of dishonor instead of it did not negate settlement. He and his agency have no capacity to pursue collection. Further collection makes him and his agency liable for $5,000 to the straw man for each attempt, and the straw man can secure its $5,000 claim. Date, notary signature, notary seal, notary stamp, notary address, administrative process number. Bam! That's how it's done. That's it right there. 3. Prepare your notice of acceptance. This is your acceptance notice, cover letter to your acceptance of the presentment. You sign it, the notary mails it, and gives you a certificate of service with her stamp on it. Oh, it's super powerful. What do you want it to say? Certified mail number. You say this is a certified document number such and such. Put the little sticker there. Name of notary, name of presenter, principal. Notice to agent is notice to principal is notice to agent. The date, the reference note, the type of notice, fax. The acceptor has accepted the presentment. The acceptor is returning the presentment. The acceptor is exchanging his exemption for a discharge. The acceptor is presenting authorization to use his exemption for court charges. The acceptor is sending processing instructions with the authorization. The acceptor is sending a statement of account showing a zero balance. The presenter's refusal to send the confirmation or notice of dishonor will not negate settlement. The presenter and his agency will have no capacity to pursue collection. Further collection makes the presenter and his agency liable for $5,000 to the straw man, and the straw man can secure its $5,000 claim. Signature of acceptor, administrative process number. 4. Prepare the notice of non-response for the notary. This is the notary's notice. This is your third-party public witness. What do you want to say? Certified mail number. Name of notary. Name of presenter. Principal. Notice to agent is notice to principal. Notice to principal is notice to agent. The date. Reference note. Fax. Notary sent notice and request by certified mail. Return receipt requested and certificate of service. The presentment was dishonored. Notary is attaching copy of first presentment to this notice of non-response. Notary is making a second request for the same thing. Performance or statement is expected in 10 days. Caveat: failure to cure the breach will be agreement of parties to the statements of the first notice. Boom, this is how you get an agreement of the parties. It's a beautiful, wonderful thing to have an agreement of the parties. Then the courts have nothing to say to you about what happens then. Do you understand? They no longer have any jurisdiction at all to say jack shit about the matter. Hey, if there's an agreement of the parties, that means you guys have an agreement. That means there's no dispute. That means the judge can fuck off. Okay? And the court could go take a hike. They could go and move on to some other more pressing business. They don't mind. They have other things to do with their time. But once you have an agreement of the parties, the court no longer has jurisdiction over the matter because there's nothing in dispute. Now, failure to cure breach will be an agreement of the parties to the statements in the first notice. There you go. Notary signature, notary seal, notary stamp. This completes the administrative process. You now have the certificate establishing A, that you accepted and returned and exchanged your exemption for a discharge. B, that your acceptance was received and accepted by the respondent twice. C, that the respondent refused to respond or comply with your request. D, that there is an agreement of the parties. E, that the respondent has no commercial energy to pursue collection. F, that you have all the commercial energy regarding the subject account. G, that you are in honor. And H, that the respondent is in dishonor.